Hello. Hello, friends in Florida. Hello, friends from around the country. Thank you for joining us, our team at Equality Florida, and advocates and members of the community from across the state of Florida and country for this important virtual town hall meeting. My name is Joe Saunders. My pronouns are he and him. I'm a former state lawmaker, the senior political director for Equality Florida, Florida's LGBTQ civil rights organization, and I'm joining you today from my home in Miami Beach. Thank you for joining us as we come together in this urgent moment. Tonight, you'll hear from some of Florida's leading experts about a range of anti-LGBTQ policies and laws that have been enacted this year by the Florida legislature and recently signed by Florida Governor Ron DeSantis. We've chosen to bring this information to you virtually and streaming on Equality Florida's platforms, in part because of the urgent need to share this information with families, businesses, and those most impacted who are working as we speak to assess the harm these new laws will cause and to plan for the future. So please like this content. Please share it. Help us get this discussion today to the folks who need it most right now. But let's start here. Yesterday, Governor Ron DeSantis hosted a press event specifically for the purpose of attacking our LGBTQ community. On the stage of a religious private school that expels students who are LGBTQ and students with LGBTQ parents, he told lies about who we are, he stoked fear about our existence, and he attacked with the full force of his executive powers our community's most vulnerable. Yesterday, Governor Ron DeSantis signed 4 anti-LGBTQ bills into law. House Bill 1069, the Don't Say LGBTQ expansion bill. Senate Bill 254, the gender affirming care ban. House Bill 1521, the anti-trans bathroom bill. And House Bill 1423, the anti-drag bill. Just days after the governor signed SB 1580, the License to Discriminate in Healthcare bill, and just weeks after he signed a 6-week abortion ban. Governor Ron DeSantis, and this is important to make clear, Governor Ron DeSantis has just signed into law the largest slate of anti-LGBTQ bills in Florida's history. And we receive this as it is intended, an all-out attack on freedom. Free states don't strip parents of the right to make healthcare decisions for their children. Free states don't ban books, they don't censor curriculum, and they don't muzzle free speech. But Governor DeSantis doesn't see freedom as a value worth defending. He sees it as a campaign slogan. He's desperate to be president, and he is setting our freedoms and Florida's reputation on fire in his desperation to win the GOP nomination. So we are here to make clear that the nation should be on high alert. Today, we are all Floridians as Governor DeSantis starts his march to export this so-called blueprint of authoritarianism to the rest of the country. Now, many of us have been asked, what comes next? Well, first, we take care of our families and we take care of our community. We do the work of educating ourselves on the landscape, on the harms, and on the opportunities to mitigate the physical, emotional, and economic damage of this slate of hate. And that's what tonight's about. For the next hour, you'll hear from current and former lawmakers, policy experts, and advocates about what is and is not in these bad policies. Now, please note that while we will do our best to provide Equality Florida and our panel's analysis, this shouldn't be interpreted as legal counsel. If you have need for this, please reach out, and Equality Florida and our team is happy to connect you to the resources that you need in this area. Now, to get us started, and I'm checking to make sure she is here. Yes, she is here. To get us started, I want to offer a very warm welcome to, and the opportunity to offer a warm welcome for one of the state lawmakers who has been one of the fiercest champions we have in the Florida Capitol. She's here to deliver some perspective from the very front line of this fight. Please help me welcome to our virtual stage State Representative Ana V. Escamani.
Well, thank you so much, Joe, for the invitation. And hello, everyone. Thanks so much for joining us. And I first want to apologize for being in my car. I actually just ran out of a commencement ceremony in my district and did not want to miss the opportunity to help share some perspective from the legislature and, of course, just set the tone for what took place in Tallahassee and what that means for all of us in our daily lives. And as Joe already outlined, this was one of the most disastrous legislative sessions when it comes to our personal freedoms and when it comes to protecting our diverse communities. 4 anti-LGBTQ plus bills were all signed into law yesterday. And I want to give you some insight into the fights that were had on the House floor and the Senate around these bills. So we knew going into the 2023 legislative session that with Governor Ron DeSantis choosing his political ambition of running for president over the needs of Floridians, that we were going to see some very extreme legislation. Of course, the years prior, when we saw the initial Don't Say Gay trans bill be pushed and signed into law, there has been a ripple effect of homophobia, transphobia, and just bigotry, not only coming out of the governor's office, but being in power to come out of all sorts of different spaces. And yesterday, actually, in the Orlando area, many probably saw that a construction sign was hacked into to include words that said, kill all gays. And so we're not being dramatic. We're not being hysterical when we talk about how severe the climate is when it comes to the health and safety of LGBTQ plus people. And of course, our leaders are making a bad situation worse. And so when we look at these bills, you know, there's so much to talk about on how horrifying each one is. And I think I'm going to really center my attention in the few minutes I have with everyone on the gender affirming care ban. Because I think that's the policy that is having the most negative experience and consequences for already marginalized people, and the one that we all have still a lot of questions for. But the reason why it's important that we fight in Tallahassee, even when we know as Democrats and as those who support the LGBTQ plus community that we don't have the votes to stop these bills, is because our fight, our tough questions, our legal questions, all of that matters. It matters not only in our efforts to persuade the opposition to oppose these bills, but it also matters in our attempts to amend these bills so they are just a little less harmful. And the gender affirming care ban legislation is one of those examples where the first version that came out of the House would have banned private insurance coverage for all adults, and it would have forced the end of gender affirming care for minors that currently receive care. And that amended version that came back to the House did not include those two provisions, though, of course, the ramifications of the current form are still horrifyingly bad, including the requirement that gender affirming care be provided by MDs and DOs, which is creating chaos, confusion, and of course, a loss of healthcare for impacted people. But it definitely was the efforts of us on the House floor, of you, the advocate, coming to Tallahassee, sharing your story, helping to break the disinformation that surrounds the LGBTQ plus community that made a difference. And so I want you to know that it's always worth fighting. And of course, our fight from the House floor now translates to our fight here in the community at the grassroots level. And what our team has been working on is not only raising money for the Central Florida Trans Care Emergency Fund, which is facilitated by the Contigo Fund and the LGBTQ plus Center of Orlando, but we've also been trying to draw some connections between providers, because we're seeing just a lot of appointments either be canceled or rescheduled and shifted. We're seeing some of our gender affirming care providers that don't have doctors on staff cancel patients and appointments as well. So these are all very real concerns for us, and we are on the ground trying to mitigate that type of harm and do what we can to support organizations and, of course, navigating the chaos of what is a policy that was implemented upon signing, which happened yesterday, but ensure that our patients who need this life-saving treatment and care are not going to be left in the dark, which is why many providers have been working overtime to provide prescriptions for several months and trying to do everything they can to mitigate this ripple effect and this effort to respond to these new horrifying and dangerous policies. And so with that, I want you to know that we're not done fighting. We're here doing everything we can to ensure access to care for our patients, to ensure that families have the resources and the legal advice and the care that they need. And we just want you to know that you are not alone and that we'll continue to do what we can during these really difficult times to ensure that those who need access to care will continue to receive it. And so with that, I'll toss it back to you, Joe. But thank you so much again for having me. And we will continue to do everything we can to fight for the needs of our LGBTQ plus community.
Thank you so much for that, Rep. Escamani, and anybody who joined us, any of the hundreds of people who joined us up in the Capitol. You know that Rep. Escamani's office was always open to us. It usually included snacks of some kind and hydration. And there were few people in the Florida Capitol who were fighting as hard against this slate of hate as you, Anna. So thank you so much for your service. Thank you for not just being an ally in this fight, but being an in the trenches accomplice. We see you. We love you. Thank you for being with us here today. Okay. So next, I want to invite to the stage our panel for the evening. It is quite a cohort of not just policy experts, but some of our state's leading experts. Between the three of you, you have probably spoken to every state, local, and national media outlet about LGBTQ rights here in Florida today, about this slate of hate. Your guidance, your analysis, your strategies were a part of crafting our community's response to this slate of hate. And I'm excited to be able to be with you here today and tell some of those stories as we also go deep on what some of these bills do. So for my friends and colleagues who are watching from home or from other parts of the country, the next part of our town hall will focus bill by bill on the slate of hate that has passed. We're going to cover, you can see on our screen here, a total of 6 bills. Now, I want to kick us off. We're going to do some introductions really quick, but I want to add this as a part of how we talk about this. When Equality Florida's public policy team began this session, on the first day of session, we woke up and we realized that what was coming. We saw that this legislature had introduced 22 pieces of anti-LGBTQ bills. It is the largest number of anti-LGBTQ attacks introduced in a single session in Equality Florida's 25-year history. And we knew that this session would be different. We never would have guessed how different. And so when we talk to you about these 6 bills today and the slate of hate that passed, what's important to know is that the substance of 17 of the 22 anti-LGBTQ bills that our community was tracking were distilled and absorbed into 8 vehicles that made it to the governor's desk. We've chosen today to center 6 of the most impactful, 6 of the most, the 6 that have the most questions for our community and require the most immediate response. So that is the focus of our time today. We'll be taking this one at a time, sort of trading off and supporting each other as a panel and how we talk about these. And also please know that there will be time for questions at the end. So if you're watching from home and you've got a specific question or you hear something that sparks a question, please do throw that into the comment section of Facebook, throw it into the comment section of YouTube or whatever platform you're watching it. We will see it and we'll be aggregating this and getting to as many of those questions as we can in the section 4 questions that we have at the end of our program today. With that, I want to throw it to my panel of experts and just the smartest people in Florida that I know for a quick introduction of yourselves, and we'll get started. Carlos, why don't you go ahead and go first?
Hi, everyone. Thank you, Joe. Many of you know me as a former state representative. I was elected to the Florida House in 2016, where I served 6 years. I was Florida's first openly LGBTQ Latino lawmaker, and now a senior member of Equality Florida staff. It's good to be here.
John Harris.
Hi, folks. My name is John Harris Maurer, pronouns he, him, his. I'm the Public Policy Director for Equality Florida, based here in Tallahassee.
And last but never ever least, Nathan.
Thanks, Joe. My name is Nathan Broomer. I use he, him pronouns. I am the president of the Florida LGBTQ Democratic Caucus and a longtime trans advocate here in Florida. Also proud to serve the state of Florida, most recently with the Florida Department of Agriculture and Consumer Services as your LGBTQ advocate with the state. That was a nice time, I remember, not too long ago. But back to you, Joe.
Thank you so much, Nathan.
Yeah.
All right, we're just going to get rolling, everybody. We have a lot of ground to cover with these bills. And the first bill that we're going to talk about is the Don't Say LGBTQ expansion bill, HB 1069. Now, what's important for folks at home to understand is that this is a separate initiative than the rule that was created by the Board of Education this year, simultaneously to the state legislature moving a piece of legislation that built on the Don't Say LGBTQ law that was passed last year. The Board of Education passed a law that bans, through rulemaking, any instruction on sexual orientation and gender identity in K through 12th grade in all grades. This particular piece of legislation, though, is different only in that it expands in statute, in law, which of course would require a different set of circumstances to repeal than a rule promulgated by the governor. And that's why we've centered it here today. So the Don't Say LGBTQ expansion bill expands the harm from last year's ambiguous Don't Say LGBTQ law and adds new provisions related to pronouns while also expanding on the governor's book banning policies. It extends the existing ban in statute on classroom instruction on sexual orientation and gender identity through 8th grade, perpetuating all of the same harms from last year, the sweeping censorship that has led to LGBTQ history being taken out of classrooms, LGBTQ teachers being told that they can't hold pictures of their families in classrooms, safe space stickers being ripped off of classroom walls, and anti-bullying programs being censored, and our communities being erased from them. All of those harms have been doubled down on by this particular piece of legislation. It's still, despite folks like Rep. Escamani and other legislators in the Capitol pushing for a clearer definition of what classroom instruction means, or even what sexual orientation or gender identity means, it still fails to define those terms. And we know that the censorship of the law, in addition to that rule that I just spoke about, we know that the statute itself will stretch its censorship into 9th through 12th grades because of language in the bill that requires, quote, age-appropriate references to sexual orientation and gender identity in accordance with state standards. And we have no faith that Governor Ron DeSantis will adopt state standards that respect our community as it relates to classroom instruction in 9th through 12th grade. There is additional language in this bill related to school pronoun policies. This language enables public K through 12 school employees and students to disrespect pronouns that do not correspond to one's sex assigned at birth. It bans school employees from providing their pronouns. It bans school employees from asking for a student's pronouns. But this distinction is important. We talked at the top of this call about how we're going to be emphasizing at times what the bills do not do. We do not interpret this bill to prohibit teachers and school personnel from using affirming pronouns. So if a student requests a certain use of pronouns, we do not interpret this law as drafted. And we may need to defend this interpretation to prohibit teachers and school personnel from using affirming pronouns. As it relates to book banning, again, this was a double down on the governor's and the legislature's book banning laws and policies already promulgated from previous sessions. But this creates the possibility for any county resident, whether they're a parent or not, to raise their hand, object to a book as, quote, pornographic, describe it as depicting, quote, sexual conduct in undefined broad ways, and have that particular book removed from every classroom library, every school library in an entire county until a time uncertain, until a process is promulgated that we don't expect to be moving fast at all, and is really, again, a double down on these book banning policies. Now, two other provisions that are important to note in this bill is that it moves the authority of the it moves authority to the Department of Education for approval of any materials related to sex education and HIV education, rather than leaving that at the purview of school districts, which has been how this has worked previously. And it restrictively defines sex to be based on, quote, genitalia present at birth, and includes language related to chromosomes, while also extending this definition through early learning through all the way up to higher ed, college, and the state university system. The effective date is July 1st, and this has, as we've already mentioned, been signed by the governor.
Thanks, Joe. The second bill we're going to take a look at is the gender affirming care ban. And similar to what Joe just described in the Don't Say LGBTQ expansion bill, there was a separate rulemaking procedure that took place over the last year around banning healthcare through a different mechanism. This is expanding and goes beyond that, but you will see some reference as we go through this about some yet to be determined answers to come from the Board of Medicine, which is an entity that falls underneath the Florida Department of Health. The top line here with this ban is it's a very broad piece of legislation that creates an overrule to parents' rights in its full entity over making healthcare decisions for their children. It also restricts, for transgender adults like me, the ability to access healthcare. We'll talk about what that means more specifically over the next couple of slides. The first top point to note is it regulates prescriptions and procedure for sex reassignment defined in this law as puberty blockers, hormones, or hormone antagonists, and surgery when provided to affirm one's sex if different from sex assigned at birth. So a really important piece here for healthcare providers is that it's adding a criminal and a licensure penalty if they engage in any of these prohibited healthcare measures. A second top line issue here is it bans gender affirming care for minors. So that's anyone under 18. The exception, and this is very important to highlight, is it does grandfather in minors who are currently under care. We are waiting, though. We do not have the rules yet. The Board of Medicine that I just mentioned will adopt those rules, and we'll have more specificity to come shortly. Regarding adult access, now only physicians, which in the state of Florida are MDs regulated through the Board of Medicine and DOs regulated through the Board of Osteopathy, only MDs and DOs can provide this care now. RNs, nurse practitioners, PAs are no physician assistants are no longer able to provide this care. There is a limit on telehealth. It's not a full out ban of telehealth, but it will require written informed consent be completed in person. So by an MD or a DO in the room at the time of receiving a new prescription or procedures, or at your first renewal of your prescription. And that is something significant. As we know, many trans Floridians receive care through nurse practitioners or online services. Now, in reference to custody agreements, this law now enables Florida courts to revise existing custody agreements when it comes to custody agreements from another state, not in Florida, but from another state when a child is in the boundaries of Florida. So when that comes to play is as direct from the new law, quote, the child has been subjected to or is threatened with being subjected to gender affirming care. So how that looks, the courts would then be able to issue a warrant to take physical custody of the child to enforce that custody agreement and avoid gender affirming care. What it does not do, and again, it's very important to maybe highlight this, it does not authorize independent investigation or removals. I know this was a strategy of concern out of Texas, among other circumstances, but that is not in this law, and we want to really make that quite clear. The status of this, just as we wrap up here too, it did become effective immediately yesterday. So this is effective when signed, and that was yesterday. And the last piece to highlight is the source of public funding as far as providing gender affirming care. So any state or local government entity which covers colleges, universities, folks employed through state and local government entities, the state Medicaid program, the state health insurance programs, anything that is public funding would not be able to provide gender affirming care. So no limitation on private insurers, but if you, your spouse, for example, if you were trans and your spouse works for a school district, and that is the mechanism that you receive your insurance and your health care, that would be impacted. So again, effective already today, signed yesterday by the governor. So it's in place today as we talk to you all. The next bill that has now been signed and will be coming into law, but not until July 1, is the anti-trans bathroom bill. So this was House Bill 1521. Top line here is this is just an abhorrent system for trans and non-binary folks. It is a ban that is very unclear. There's a lot of words in this law that need some clarification. The enforcement mechanism also unclear. Agencies are going to have to come up with their own rules or guidance, but it's unfortunately in place now. And what will it require? So depending on the regulated building, and these are in several different aspects of public domain, it would require regulated buildings that have a bathroom or a changing facility that at a minimum, they have segregated facilities by sex assigned at birth or a unisex facility. So a single user or single family facility. So where available, of course, the recommendation here, of course, it doesn't allow unisex facilities to not be in place. Accessing those, of course, would be something encouraged and recommended. In addition, this now law creates a liability for entering the bathroom. So a number of things have to happen here for this to rise to a penalty. If you enter a bathroom or changing facility assigned based on sex assigned at birth, designated as they've defined for the opposite sex, and you refuse to leave upon request, this is when the penalty aspect of the law comes into place. Either discipline if you are internal within the organization or the entity, or a trespass if you're a public member coming into the facility. Also very clear to point out, it isn't just any member of the public that can ask you to leave. For the particular facilities that we'll highlight, including correctional facilities, educational institution, and government buildings, like City Hall, it has to be a certain employee as defined by the new law. So as I mentioned earlier, it has been signed, but it does not become effective until July 1. But that is the anti-trans bathroom bill. Joe?
Thank you so much for all of that, Nathan. And for those that have questions based on this, I know we're moving fast and covering a lot of ground. Please do throw those questions into the chat. We'll be aggregating as many of them as we can, and we'll get to as many of them as we can in the time we have today. Next, I want to bring to our virtual stage to talk about the anti-drag bill, former state representative Carlos Guillermo-Smith.
Thanks, Joe. So I'm here to talk tonight first about Senate Bill 1438. So 1438 is the anti-drag bill that you saw so much about in the news. And I think it's important to talk about what the point of this bill is and help everyone understand what the consequences are of its language. Because the bill, at the end of the day, is about attacking and censoring drag queens and drag performances, specifically those that take place in front of minors. They're using this law to create fear and intimidation and to scare our pride organizers at the local level and to scare LGBTQ friendly businesses out of wanting to host drag performances altogether and closing their doors. The way that they're doing that through this bill is by using vague and subjective language. They're using harsh penalties like $10,000 fines and fees for businesses, jail time for those who admit minors to what they define as an adult live performance. They're using the vague language and the harsh penalties as a sword to encourage you, to encourage our community to self-censor when you don't have to. And the law does not require you to do so. That is their goal. So let's talk about how this bill, which is really trying to just erase drag from our culture and push us back in the closet, really impacts performers, venues, and pride events. First of all, what is the bill and what does the language say? This is a bill and a law that applies to adult live performances that admit minors, anyone under the age of 18. If we're talking about a drag performance at a bar that is 21 and up, for example, or even 18 and up, this does not apply at all. This is adult live performances as they define it in front of minors. So what is an adult live performance? Here's where they come in with the vagueness. An adult live performance is defined as any show, exhibition, or other presentation to a live audience involving one of 9 different elements that they define, which includes lewd conduct, or simulated nudity, or lewd exposure of prosthetics. And it has to meet a highly subjective 3-part test. Nowhere in the definition of adult live performance does this law mention drag performances, or drag queens. We know that the bill intentionally targets drag because the sponsors of the bill have said that, and because yesterday when Governor Ron DeSantis signed this bill into law along with others, they handed out a flyer that talked about how they wanted to basically include drag shows in their enforcement of this law. They specifically cited drag. But we already know that drag performances are going to have a target on their backs, regardless of whether the word drag or drag queens or drag performances is mentioned in the bill. Now, what are these fines and fees that are so excessive? What are the penalties that is being used here to scare folks out of hosting drag? Well, first, they are charging individuals who admit, anyone who knowingly admits a minor into an adult live performance, they would be subject to misdemeanor crimes and the jail time that comes with that. Who admits a minor into a drag show? That could be someone who works for a theater that has drag queen performances that include family-friendly performances that they admit into the show that the state then later deems to be an adult live performance using their subjective language. It also means someone, a pride organizer, perhaps that received a permit from a city or from a local government that allows for what they define as adult live performances to happen on public streets or sidewalks where minors are present. They could be charged with misdemeanor crimes under this bill. What it also does is it threatens a $5,000 fine for the first violation on businesses who admit minors into these prohibited performances, and a $10,000 fine or fee for the second violation and subsequent violations. Those are steep fines and fees that no one wants to pay. And what it also does is it threatens small businesses that host prohibited performances in front of minors. It threatens to revoke their liquor license, which we know is their moneymaker, which often keeps them in business. Or it threatens to also revoke their business license altogether and shut the business down. What does this mean for local prides? We've heard a lot in the news. We've already seen pride organizers in certain cities have had, rightfully so, lots of questions about what this means for their pride. Well, the reality is that it is specifically saying, again, that pride organizers who obtain a permit with it that includes adult live performances in front of minors are the ones that would be subject to these penalties, specifically the misdemeanor crime. It does not ban pride. It does not ban pride parades, and it does not ban drag performances indoors or outdoors. So I think it's really, really important that folks understand those provisions of the law. The governor signed this law yesterday. The effective date was actually the day that it was signed. So unlike others, we're not waiting for July 1st for this to become effective. It is effective immediately. And here's what my closing thoughts on this bill overall, based on what we've already seen transpire as a result of the passage of this law and in the lead up to it. Of course, remember, it's not a ban on drag. They are using vagueness as a sword to intimidate our community into silence. So while this is not legal advice from Carlos, and it is not legal advice from Equality Florida, I will tell you this: do not give them what they want. Know the facts. Understand the law as it is written. Do what you can to protect your event and your community and your business from being targeted by the DeSantis administration, because we know that they are willing to target those LGBTQ friendly businesses for political reasons. And carry on. The shows must go on. We should proudly raise our flags. That is a form of resistance during these times again. And we should continue celebrating drag.
Well said. Well said. Thank you, Carlos.
All right. And the next bill we wanted to discuss is the quote unquote license to discriminate in healthcare bill, Senate Bill 1580. This was one that raised a lot of concerns throughout the process because we saw it pushed by far right interests, the same that we're often getting up in committee and opposing LGBTQ equality. And it's really putting personal beliefs over patients' well-being. So it does so by allowing healthcare providers or healthcare payers to claim what they call conscience-based objections. So a conscience-based objection is rather vague, but it can be anything based on religious, moral, or ethical beliefs that, again, a healthcare provider or a payer would raise to refuse to provide healthcare service or coverage. We know and understand that things like religious freedom are very important. That's why they are already protected. But we have a lot of concerns about, again, these sort of nebulous terms like conscience-based objections and how folks would substantiate what those particular beliefs may be. It's worth noting this applies very broadly. The definition for a healthcare provider is incredibly expansive to basically any individual who is licensed, not just doctors, nurses, even medical students who are not yet licensed, that are involved in provision and delivery of healthcare, and entities, so things like hospital systems or doctors' offices, arguably. And it also covers healthcare payers. So what we most frequently think about is insurers there, or potentially employers who are providing insurance coverage for employees. And the fact that those employers or those insurance companies then could refuse to cover a particular service because of this quote unquote conscience-based objection. So it is very important in this bill, as others, that we recognize where our rights are and that we distinguish between what the intent of the law is and the impact is. And this is a space that folks rightly have a lot of concern, because we've seen how there are disproportionate burdens for the LGBTQ community, particularly the trans community, for accessing healthcare, and how they can face greater rates of discrimination in trying to access healthcare. But it's a place where we've really got to hold them to the letter of the law, because the law is that those objections have to be based on a healthcare service that this provider or payer is refusing, not the patient. So under this law, the healthcare provider or the payer should not be able to say, I am not going to serve this person or this patient just because they're LGBTQ. We heard an example about this in some of the discussion that one of our other legislative champions, Representative Michelle Rayner, brought up on the floor, talking about access to birth control, and basically got the sponsor to say, somebody shouldn't be able to, under this law, deny somebody access to birth control when it is for the purpose of preventing a pregnancy if they are prescribing that exact same birth control for other hormonal regulation. Again, it is about a refusal to that service altogether, not about the identity of who is asking for it. There is specific language in the bill that says that the bill does not allow discrimination on the basis of race, color, religion, sex, or national origin. Again, very important overall and very important for the LGBTQ community, because we have federal case law that says when you talk about discrimination on the basis of sex, that includes discrimination on the basis of sexual orientation and gender identity. Basically, somebody cannot discriminate against you on the basis of sexual orientation or gender identity without considering sex. And if they're doing that, then they would be in violation of this law. Also worth noting, we've heard, again, a lot of people concerned about this bill, and particularly how it could impact access to emergency services. The bill expressly does not override state and federal protections that ensure that healthcare providers and payers have to provide that emergency service. So this is another one of those bills that has already been signed by the governor, and it will be going into effect on July 1st.
John Harris, before you move on, can I just put a big highlighter on what was a sub-bullet on that last thread? It's already come up in the comment thread. This is something we've heard a lot. There is express language in the license to discriminate against healthcare bill that does not allow the implications and powers of that law to stretch into emergency care. That has come up a lot in the press coverage around this. It is not something our community should need to be worried about. We may need to defend that and to push for a promulgation of that interpretation, which is clearly, unequivocally baked into the law.
And I will hand it over to Carlos.
Thank you. And I don't know if you heard that very loud thunderclap in the background, but it's just a reminder of how bad these bills are and why we need to arm ourselves with information so that we can fight back against them. So I'm talking to you now about Senate Bill 266. This is a bill attacking diversity, equity, and inclusion, as well as academic freedom in our higher education institutions. Everything about this bill that I'm about to tell you applies to all of Florida's state colleges. That's the Florida college system, and all of Florida's public state universities in the state university system. What does this bill do? Well, you probably heard a lot about the higher education changes in the news this session because of how much they're really impacting higher ed. But this is ultimately what passed. It's a bill that censors politically disfavored viewpoints in curricula in our state universities and colleges, namely in general education core courses. It defunds diversity, equity, and inclusion initiatives at all state colleges and all public state universities, period. And these are the types of programs that we know help LGBTQ students and other minority students thrive. Talking about the censorship, because we know that censorship is a central theme of the DeSantis administration and of this Florida legislature. How are they censoring higher education? What is it exactly that they're prohibiting as part of curricula? They are specifically saying that general education courses in our state colleges and universities may not distort historical significant events, and they may not teach identity politics. There's no definition of identity politics, and there's no explanation of what distorting significant historical events means. So here we are with the vagueness. It also says that general education courses cannot include theories that systemic racism, sexism, oppression, or privilege are inherent in United States institutions and were created to maintain social, political, or economic inequities. So all told, what's happening here is the state law is prohibiting in higher education classes with grown adults that general education courses cannot include these topics that this administration and this governor do not like, which is very ironic because this itself is indoctrination in higher education. What courses are they going to ban? Was there a list of courses that were included that would have to be pulled or would have to be removed? Well, not yet. What is going to be required is the Board of Governors and the Board of Education. These are the two bodies that govern the public university institutions and our state college institutions. They are going to need to issue their own rulemaking and their own guidance talking about the types of courses and the specific courses that would be prohibited and the specific topics that would be prohibited and what the impact would be on individual courses. They are going to need to develop that. So we don't have all of the answers yet on what courses will be canceled or which ones will be pulled. That is going to be the same with the defunding of diversity, equity, and inclusion and which programs are going to be impacted. So getting to this part, because this also got a lot of attention, what this law says is it prohibits state universities and colleges from spending state or federal funds on programs that advocate for diversity, equity, or inclusion and are not already required by state or federal law. Is there a definition of diversity, equity, and inclusion? No, there's no definition. Are you noticing a theme here with the vagueness? Now, who is going to tell us whether a program at UCF or UF or FSU or USF or any of our institutions, whether that counts as a diversity, equity, or inclusion program that we have now completely defunded? Well, we are going to have to wait for the Board of Governors and the Board of Education again, who will develop definitions, and they will provide insight and guidance to the boards of trustees at these higher education institutions to tell them exactly what diversity, equity, and inclusion means and what types of programs would be totally defunded. Now, you're probably wondering, well, what even is a diversity, equity, and inclusion program? Well, I mean, a lot of these programs are very broad. They cover outreach and support for minority students and LGBTQ students. This can threaten the existence of multicultural student centers, Black student unions, and campus pride centers that are not already required by law. And in this case, this law is effective July 1st, 2023. It was already signed by the governor, I believe, last week. And if you're wondering, what do we do now? I do want to take a moment to briefly say my non-legal advice, but my advocacy advice. Every state university and every state college has a board of trustees. This board of trustees, basically, many of them are appointed by the governor. They are the ones who should be giving students, faculty, and everyone in their campus community answers right now on how this law impacts courses that are currently being offered and programs that may be defunded and abolished under the defunding of diversity, equity, and inclusion programs. While, yes, they will be waiting for the Board of Governors and the Board of Education to issue guidance and more specific rules and definitions, these boards of trustees do answer to their students, their campus communities, and their faculty and staff. And they absolutely should be pressured into providing answers for how they will defend these programs, what will happen to these programs and courses, and how your universities and colleges will move forward under this new law. And that's it.
Thank you for all of that, Carlos. And as we phase into questions, we won't go deep into this slide here, but this slideshow will be available to those of you who want it. And I'm going to leave it to one of my panelists to remind me how people can get access to it. I think the answer is that if you RSVP'd for this through a link that was shared, that's how we'll have your email and we'll send it to you. But someone can correct me if that's wrong. But we did want to provide this guidance here on bills that were part of the 22 anti-LGBTQ bills that were filed but did not make it to the governor's desk, or provisions in these bills as they were originally filed that were removed. And we share that, one, because the process of making sure our community is fully educated on where we are now does involve people being caught up. For example, Nathan talked about how in the original draft of the gender affirming care ban, there was an express sweeping ban on all private insurers in the state offering in any health insurance package gender affirming care. We fought really hard to get that language taken out. It was taken out in the Senate. It did not make it into the legislation that made it to the governor's desk for his signature. So for those wondering on that about that distinction, what's been taken out, where are we now? This is an important slide. I invite you to study. And if you'd like more information about this, John Harris, I think I heard you jumping in.
Yes, correct, Joe. As you noted, for folks who want a copy of the slide, make sure that you have completed the RSVP for tonight's program. If you already have, then we've got your email. You're great. I do believe it's also been posted on Facebook and maybe YouTube if you need that link, or you can find it on Facebook to sign up. Make sure you get those materials. But as Joe was saying, this slide, while we won't go into detail about all these measures, really important for folks to be aware of, just because so many of these bills have changed throughout the process. And there are some really important things that are no longer in those bills, but may still be causing a lot of concern. So just two quick examples. First, around the bathroom bill. Originally, it was incredibly sweeping and would have applied to virtually all like private spaces, restaurants, healthcare facilities, what have you. Really important to recognize that that has been narrowed, while it is still a terrible bill, to only be applying to educational institutions, corrections and detention facilities, and government-owned or leased buildings. Another that is not listed here, but I've heard a couple questions about, is in Senate Bill 254, the gender affirming care bill, around the custody provisions. Again, there are very narrow circumstances where those operate, and it comes into play when you have a custody agreement from out of state and the minor is in state. But one of the things that was in the original version of the bill is not now, was about basically allowing custody agreements to be modified if the parents were accessing gender affirming care or other siblings were accessing gender affirming care. Important to note that that is not in the final version of the bill. So again, if folks have questions about things we haven't touched on tonight that you heard about before, it could be because they've been taken out of the bills, and we're happy to answer some of those questions too.
Thank you so much for that, John Harris. Now, John Harris, I know that as we've been moving through this, there have been lots of questions in our comment threads. You've been capturing as many of them as you can. We've got about 10 minutes little over 10 minutes to spend time on some of those questions, but I'm going to pass the microphone to you to lift up the ones that you think are most helpful to cover in the time that we have, and to throw it to our panel here to help get our folks information they need.
Absolutely. So one of the first questions I wanted to pivot to, Nathan, I think this is probably most in your wheelhouse, was around how could they ever enforce the anti-trans bathroom bill? Any other thoughts on that legislation?
Yeah. So what's in the bill? Yes, that's the reasonable response to that. The bill. So what's in the bill is the idea that individual institutions are supposed to create procedures and determine who the authorized employees are that would then monitor, right? Be able to enter the restroom and then ask you to leave. I know it sounds unreasonable and it will likely not be uniform, but that's what's in there in essence. So thanks, John Harris.
Absolutely. And another question, Carlos, if you want to jump in on this one, or Joe, asked if the curriculum bill prohibits instruction on all gender identity content.
That's a good question. It does not. What it does prohibit is it prohibits from general education core courses teaching identity politics. So really what we're trying to understand is, what does that mean? We don't know what identity politics means because it has not yet been defined. What we did see with the bill earlier in the process before it was changed was that early versions of the bill actually abolished certain degree majors and minors. They did things like abolish women's and gender studies and queer theory and a list of other subject matters and specialties that were degree minors and majors from being allowed to be offered. But again, those provisions of the bill were removed. There is no restriction on specific minor degrees or majors that can be offered. However, the catch is that there are restrictions on general education only courses, and we still do not have a definition on what identity politics means and how that would impact some of the course offerings.
Thanks, Carlos. And the next question I'll direct to Joe, and that was, does the drag bill prohibit minors from attending quote unquote adult live performances even when their parents bring them?
The shortest answer is yes. So, and it points to an important hypocrisy that has come out of the Capitol and is related to many bills within this slate of hate. The anti-drag bill has severe penalties for the venue itself, for the municipality that may host the Pride event, for example. If a person under 18 is present, regardless of whether or not their parent literally brought them to it. And that sort of the hypocrisy around parental rights is present in the Don't Say LGBTQ law, which has sweeping book banning legislation and language, right? So if one parent in the Don't Say LGBTQ expansion bill's book banning provisions, according to it, if one parent in a county, or even not a parent, when a random far-right activist raises their hand and tags a book as supposedly, quote, pornographic, that book is taken out of a classroom, regardless of if every single parent who has a student in that classroom wants that book to stay. So the fallacy of parental rights being what is driving the Don't Say LGBTQ bill or any of these bills in the slate of hate, in the gender affirming care ban, it is a direct attack on parents who are working with doctors to get health care for their own kids. And I think that's a hypocrisy worth putting a highlighter on.
We had another question asking about how the Don't Say LGBTQ bill affects intersex individuals? And I think this is a good question because it actually cuts across a few different bills. Several of the bills do make acknowledgement of intersex individuals. That's not something we have often seen the legislature do. But recognizing that, for example, the bathroom bill would not apply to intersex individuals. We can talk about bills on sort of a case-by-case basis. I would say a lot of the rhetoric we saw around defining sex, again, refers to things like chromosomes and genitals present at birth that are exclusionary. But there are some important places where intersex conditions have been accounted for and acknowledged, even if only that the legislation is sort of saying, frankly, we don't know what to do in these scenarios. So happy to get into more detail on that if there are specific questions. And with that, I will go to another question. Nathan, I think in your wheelhouse.
All right.
The question was, will adults already receiving hormone therapy have to fill out consent forms to continue treatment?
Good question. So what we're clear is in the new law is that informed consent forms, which will be developed by the Board of Medicine, would be completed when receiving a new prescription or a new procedure or at first renewal. So I think if your question is you're currently receiving care and then you go in for that first renewal, and I think logically for a lot of providers, there might be a lot of folks that might see that in the stack of paperwork when you go, just to cover once this new form is done, it's in the chart, and they're just going to make sure they're covering all their bases, which, but we have not seen the form, and that will take some time to develop.
All right. Another question we saw several times in the chat was about litigation and legal challenges to these bills. We do expect that these bills will be challenged. In fact, some pending litigation has already been petitioned to amend it to include a challenge to the gender affirming care bill, Senate Bill 254. Specific provisions of that bill, but I don't think that's the last word we'll see about this. We've been talking to legal partners throughout the course of session. They've been testifying in committees, helping us develop strategy, and they're very focused on a lot of this legislation. So we can't say exactly sort of which partners will be challenging which bills at this stage, but we do expect to see those challenges. We know that there are serious legal issues, constitutionality issues with these bills. I wish that those would stop bad bills in the legislative process, but we've seen even places where lawmakers advance those bills specifically because they want to challenge existing laws. Any other comments on that?
Yeah, I'll just add this thought to that because I think it is important, and we're not going to do most of this today, y'all. This isn't the town hall or the discussion as a community to talk about all of the different things that come next from an organizing perspective and an action-based perspective. But I do think it's important for everybody to stay very sober in the reality that we cannot count on the courts to save us. That it was politics and elections and a lack of enough energy to build the walls and shields to protect us from this that got us here. We've been here before. We've dealt with terrible laws in Florida before. It was the ban on adoption by gay and lesbian parents that called folks like me and Carlos very initially into this work almost 20 years ago. We know how to take down bad bills, but even as we engage in the process of litigation, let's just keep reminding ourselves that it is going to take political power and organizing in every single county in this state to, one, stop Ron DeSantis, and two, to change a legislature that was willing to capitulate to his ambition and his politics at the expense of our communities. Both things can be true at the same time, and that's part of the path that comes next.
All right, and just a few more questions. I realize we've gone over the hour, but wrapping up shortly, trying to get into as many of these as we can. Nathan, there was a question about the bathroom ban and what particular schools it applies to. If you can talk us through that a little bit.
Yeah, I think I saw a question about charter schools. Essentially, the bill, this new law does apply to both public and private institutions, K through 12. So that would include charter.
All right. And next to Joe, on the Don't Say LGBTQ pronoun provisions, there's a question: if another parent or teacher objects to my child's pronouns, would they be forced to go by their birth pronoun?
I may need your help with that one, John Harris. What's your take?
Yeah, I think it's a little different depending if it's parent or teacher. Again, the operative issue here is basically that school employee, teacher, administrator can't be forced to use affirming pronouns. So if that teacher objects, then the teacher wouldn't be compelled to use the proper pronouns. An objection raised by another parent,
Right.
I think sort of falls outside the scope of the legislation. So I don't really see a space for that.
Yeah, I agree. And that's where I got stuck, was the question of another parent. We heard over and over again in the process, in the legislative process, we heard the bill sponsors affirm over and over again in debate that the intent of their law was to not require effectively a transphobic or a homophobic teacher to by some sort of punitive way to acknowledge the pronouns of a transgender student or a transgender faculty or staff member. And I thought there was some really smart policy that was brought forward by Democrats that said, and what if it is the will of the parent of the trans student? Who gets supremacy there? What about the parental rights of a trans student who's effectively being bullied over and over again every day by a transphobic teacher? That great policy did not make it into the law. And so that's how we interpret that today.
Thanks, Joe. One more question on the license to discriminate in healthcare. I saw a question about if I get in a car accident and the people who show up raise conscience-based objections as first responders, can I be left in that situation? Again, no, there's a really important acknowledgement in that legislation that emergency services cannot be denied. So I think it's a place where, again, we're going to have to watch implementation closely. There's a lot of really critical medical care that may not rise to the threshold of being quote unquote emergency care. But it's a place where folks should consistently be pushing and acknowledging their rights that, again, refusal has to be based on a service somebody doesn't want to provide. It can't be based on the identity of that patient. And with that, I'll wrap up with one final question and leave it to the group, anybody who wants to jump in. There was a question about what can we do to protect ourselves and our loved ones given this broad slate of attacks on the LGBTQ community and particularly the trans community?
Well, I think it's important that folks educate themselves with the facts. We talked about that throughout the town hall. There are serious harms with so many of these bills, and it's important that folks take it upon themselves to distinguish between fact and fiction and also understand how the bills do and do not impact them so that they can take the proper measures where necessary to protect themselves and protect their families.
Yeah, I'll actually jump in there to reiterate what Carlos said. There's a lot of misinformation or misunderstanding about the legislation. Please do consider Equality Florida a resource. Reach out to us with those questions. If we don't have an answer, we can try to get you in touch with a partner that may. We're seeing a lot of confusion right now, and I would say some sort of overreaction and over self-policing or over self-censorship because of folks concerned about the liability here. Again, issues we talked about, like this is not a ban on all drag or all pride, so there's not a reason for those events to be canceled. There are specific scenarios where there may be issues. We're happy to help you talk about the specific circumstances where those may come up. But sort of our opponents win if we go overboard in this implementation. I know it's something that Nathan's been hearing a lot about too in the gender affirming care space. And we have a lot of providers who understandably are really concerned about their licensure and how they move forward under these new laws that immediately went into effect when they were signed yesterday. But that access to care is so important. So we're trying to work with providers and help them understand how they can make sure that they are in compliance with these new requirements, rather than just closing their doors. But if you are one of those folks who is having issues with access to care, please do reach out to your providers sooner rather than later, so that you can hopefully find a pathway that will work.
Yeah, I think I'll jump in here. I'll put on a different hat, I guess. As a former teacher here in the state of Florida, in a past life, I was an educator, and I saw a lot of comments or a lot of questions in the comments about what this will look like, especially for LGBTQ folks. And I honor one person even mentioned that they're trans and they're a teacher. I think there are a lot of unanswered questions. So in taking care of yourself and your loved ones, there are a lot of things that are not in these laws, right? So they can't legislate our identities, right? They can't tell us not to use affirming names and pronouns if we're within the systems and we're affirming those LGBTQ youth who are our students. There's no prohibition against that. And I think, do proactively the taking care of yourself, especially when you are also taking care of others as they come through your doors every day and every week. And I appreciate that you all are doing that. And I will also say, I guess, putting back on my attorney hat, there will be folks that will challenge your ability to do your job and what that means. And if you need to, just like you should reach out to Equality Florida, I would also say check with your union and also contact an attorney if you need to. I am sure folks will want to test us, but more than anything other than within our own families, within community, take care of yourselves emotionally and spiritually and intellectually by staying connecting to all the beautiful parts of our community across the state, wherever you happen to be. I'm grateful that Pride Month's coming up and might look a little different in some parts of the state, but we will celebrate together. We will affirm each other, and we do it better than any community I've ever been a part of, and carry on. We will get through this. Thanks, Joe.
Thanks, Nate. I do want to add to that too, and just say, listen, it is important for us to center LGBT joy, trans joy, gay joy, bi joy. Like, we need to center that as part of our struggle, and center that to remind ourselves of what we're fighting for and what freedoms and rights we are fighting to protect. And for the LGBTQ youth that is perhaps watching this today, for the trans community that is experiencing a lot right now under these attacks, just remember that you're loved, we've got your back, and we will continue fighting for all of you, no matter what. We won't win every battle, but we will fight every fight.
Hear, hear. Well, I want to thank everybody for joining us today. I want to thank my esteemed panel. There are few trenches I would want to go into without the three of you. And I know that the four of us represent here on this call an army of advocates, activists, lawyers, organizers, who really hundreds of people who came to the Capitol to form a wall of resistance to this slate of hate. We fought every single fight. Carlos is right. We were in every single venue that they challenged us in. We are committed as Equality Florida, and as a broader cohort of LGBTQ community leaders in this state, to continue that struggle. Please stay tuned. We have more programming for you. If this was helpful to you, and you lead an organization where a deeper dive like this is of service to your mission, we are here for that as well. Please reach out. But thank you all for joining us here today. Again, like this content, share this content. Let's get it to the folks who need it most right now, and take care of yourselves. Thank you for joining us.
Thank you.